The night air hung thick and humid over the Georgia interstate, that particular kind of southern summer heaviness that makes every breath feel deliberate. At precisely 10:47 p.m. on a Wednesday evening, a charcoal gray Lexus sedan cruised southbound on Interstate 75, maintaining exactly 65 miles per hour. The driver's hands rested at 10 and 2 on the steering wheel, a habit born from decades of careful attention to rules and procedures. Behind that wheel sat a woman whose entire professional life had been dedicated to one singular principle, that the law, when properly applied, serves as the great equalizer in American society. Her name was Denise Thornton. At 53 years old, she had served on the federal bench for nearly 11 years. She had presided over complex civil rights cases, corporate fraud trials, and constitutional challenges that had shaped legal precedent across the southeastern United States. On this particular night, she was simply a tired woman driving home from a 3-day judicial conference in Atlanta, her mind already drifting toward her own bed, her own kitchen, and the quiet comfort of her home in the suburbs of Macon. The conference had been productive but exhausting. Hours of panel discussions about sentencing guidelines, debates over procedural reforms, and countless conversations with colleagues from across the circuit had left her mentally drained. She had declined the option to stay another night at the hotel, preferring instead the 2-hour drive south. The road was familiar, the traffic minimal at this hour, and she found a certain peace in the solitude of night driving. What Denise Thornton could not possibly know was that her unremarkable journey home was about to become anything but unremarkable. She could not know that within the next several minutes she would become a victim of the very injustice she had spent her career fighting against. And she certainly could not know that the events of this single night would eventually expose a pattern of abuse so deeply embedded in one local police department that it would shake the community to its foundations. If you've ever wondered what happens when someone who has dedicated their life to upholding justice suddenly finds themselves on the receiving end of its opposite, stay with me through this entire story. What unfolds here is not just about one traffic stop or one officer. It's about a system and what it takes to finally force that system to change. Behind a weathered billboard advertising a local car dealership, a Dodge Charger patrol vehicle sat in darkness. The engine idled quietly, and behind the wheel sat Deputy Kevin Mercer of the Clayton County Sheriff's Office. At 36 years old, Mercer had been patrolling these highways for nearly a decade. He had developed certain habits over those years, certain patterns of behavior that his supervisors had occasionally noted but never seriously addressed. Mercer watched the interstate through narrowed eyes, his attention drifting between the occasional passing vehicle and the screen of his personal phone. The night had been slow, which he found irritating. Slow nights meant fewer opportunities, and Mercer was a man who liked opportunities. He liked the rush of authority that came with pulling someone over, the moment when a driver's face shifted from confusion to concern to compliance. He particularly enjoyed those stops where he felt he had the upper hand from the very beginning. When the charcoal Lexus passed his position, something caught Mercer's attention. Later, when pressed to articulate exactly what had drawn his focus, he would struggle to provide a coherent answer. But in that moment, something about the vehicle or perhaps its driver triggered a decision. He set down his phone, shifted the patrol car into drive, and pulled onto the interstate, accelerating to close the distance. For nearly 2 miles, Mercer followed the Lexus, maintaining a distance of roughly 50 yards. His dashboard camera recorded everything, the Lexus maintaining its lane perfectly, signaling appropriately, traveling at precisely the posted speed limit. From a legal standpoint, the vehicle ahead of him was operating flawlessly. There was no traffic violation to document, no erratic behavior to report. And yet Mercer continued to follow. Inside the Lexus, Judge Thornton had noticed the headlights behind her shortly after they appeared. As any cautious driver would, she glanced periodically in her rearview mirror, noting the vehicle's steady presence. When she recognized the distinctive shape of a patrol car, she felt a brief moment of natural alertness, the kind any motorist experiences when law enforcement is nearby. But she quickly dismissed any concern. She was driving exactly as she always drove, carefully, legally, and with complete attention to the road. Then the blue lights erupted behind her. The sudden illumination flooded her mirrors and splashed across her rear windshield, casting dancing shadows across the interior of her car. Judge Thornton felt her stomach tighten, that instinctive human response to unexpected confrontation with authority. She immediately began scanning her mental checklist. Had she been speeding? No, she had checked her speedometer just moments ago. Had she failed to signal? No, she hadn't changed lanes. Was one of her lights out? Possible, she supposed, though unlikely. She activated her turn signal, checked her mirrors, and began a controlled deceleration toward the shoulder. Even in this unexpected moment, her movements were deliberate and careful. She had handled thousands of cases involving traffic stops, had read countless depositions from both officers and civilians about how such encounters unfolded. She knew the protocols, understood the procedures, and was determined to conduct herself with the same measured professionalism she expected in her courtroom. The Lexus came to a complete stop on the gravel shoulder, its hazard lights blinking in rhythmic pulses. Judge Thornton put the vehicle in park, lowered her window, and placed both hands on the steering wheel where they would be clearly visible. Her license and registration were in her purse on the passenger seat, but she knew better than to reach for them unbidden. She would wait, as protocol demanded, for the officer to approach and issue instructions. Deputy Mercer took his time exiting the patrol car. He adjusted his belt, checked his radio, and began a slow walk toward the Lexus. His flashlight beam preceded him, sweeping across the trunk, then the rear window, then illuminating the interior of the vehicle. When that beam reached the driver, it lingered there, taking in the image of an African-American woman in professional attire, her hands clearly visible on the wheel, her posture composed and still. Something shifted in Mercer's expression, though the darkness and the angle of the light would have made it difficult for anyone to read precisely what. He approached the driver's window with a particular kind of energy, a stance that suggested confrontation rather than routine inquiry. License and registration. The words came without greeting, without explanation, without any of the standard phrases that typically open such encounters. Judge Thornton nodded slightly. "Good evening, officer. My documents are in my purse on the passenger seat. May I reach for them?" Mercer's flashlight beam moved to the passenger seat, examining the leather bag that rested there. "Go ahead, slowly." With movements that were almost ceremonially careful, Judge Thornton reached across and retrieved her wallet. She extracted her driver's license and the registration card she kept clipped behind it. As she handed them through the window, she allowed herself the question that had been building since the lights first appeared. "Officer, may I ask why I've been stopped? I believe I was traveling at the speed limit." Mercer examined the documents with his flashlight, taking a notably long time to process information that should have been straightforward. "I'll ask the questions here. You were displaying suspicious driving behavior." The judge felt a cold weight settle in her chest. In her decades of legal experience, she had heard this phrase countless times, always in depositions, always as a pretext, always when the real reason for a stop could not be legally articulated. Suspicious driving behavior was the refuge of officers who had no legitimate cause but wanted the authority to stop someone anyway. "I apologize, officer, but I'm not sure what you mean by suspicious behavior. Could you be more specific?" Mercer's jaw tightened visibly. "You don't need me to be specific. I'm the one conducting this stop. Where are you coming from tonight?" "I'm returning home from a professional conference in Atlanta." "What kind of conference?" Judge Thornton hesitated. In her mind, she weighed the options. Revealing her profession might resolve this situation quickly, but it could also escalate things in unpredictable ways. Some officers responded well to learning they had stopped a member of the judiciary. Others reacted with hostility, as if the very presence of legal authority somehow challenged their own. She decided on a middle path, answering the question without volunteering more than was asked. "A legal conference. I'm an attorney." This was technically true. All judges were attorneys. It was also strategically vague, but Mercer seemed to find something in the answer that increased his agitation rather than alleviating it. "An attorney, driving this car, at this hour, on this road." The implication hung in the air, unspoken but unmistakable. Judge Thornton had presided over enough cases to recognize the subtext immediately. In Mercer's mind, certain people drove certain cars, lived in certain neighborhoods, held certain jobs. When reality contradicted those assumptions, it became suspicious rather than simply unremarkable. "Step out of the vehicle." The command came suddenly without justification or warning. Judge Thornton felt her pulse quicken, but she maintained her composure. "Officer, I'm happy to cooperate, but may I ask why you need me to exit the vehicle? I've provided my documentation and answered your questions." I said, "Step out. Now." There are moments in life when we must choose between asserting our rights and ensuring our survival. Judge Thornton, better than most, understood this terrible calculus. She knew that legally she could refuse this order absent probable cause. She also knew that such refusal could result in physical force, arrest, or worse. She had read too many cases, seen too many depositions, heard too many tragic outcomes to believe that being right would protect her in this moment. She opened the door slowly and stepped onto the gravel shoulder, her heels finding uncertain purchase on the loose stones. The night air immediately wrapped around her, humid and close. Passing vehicles created brief hurricanes of wind that tugged at her clothing as they streaked past. "Turn around, hands on the vehicle." Judge Thornton complied, placing her palms flat against the warm metal of her car's roof. Behind her, she could hear Mercer's footsteps on the gravel, could sense his approach without seeing it. When his hands made contact with her shoulders, she had to suppress an involuntary flinch. What followed was a pat-down search that pushed against the boundaries of any reasonable definition of a safety check. Mercer's hands moved slowly, thoroughly, with a familiarity that felt deliberately invasive. Judge Thornton stared at the blurred reflection of blue lights in her car's paint, willing herself to remain still, to remain silent, to endure this violation with the same discipline she brought to every other challenge in her life. But inside, something was breaking. Here she was, a federal judge, a woman who had dedicated her life to the principle that every person deserved equal treatment under the law, being subjected to treatment that was anything but equal. In this moment, her robe and gavel meant nothing. Her years of service meant nothing. To this officer, she was simply a black woman in a nice car, and that was enough to justify whatever he chose to do. "I'm going to call for backup," Mercer announced, stepping away toward his vehicle. "Don't move. Backup." For a routine traffic stop with a fully compliant driver, for a situation that had produced no evidence of any wrongdoing whatsoever, Judge Thornton understood exactly what this meant. The stop was being escalated not because circumstances required it, but because Mercer wanted it to escalate. He was building toward something, constructing a narrative that would justify whatever came next. She stood alone on that highway shoulder for 12 minutes, cars streaming past in both directions, their occupants glancing at the scene of flashing lights and the solitary figure posed against a luxury vehicle. Some surely assumed they were witnessing a criminal being apprehended. Others might have wondered what had happened. None of them stopped. None of them knew that they were witnessing a federal judge being subjected to treatment that would eventually expose a decade of civil rights violations. I want to pause here and ask you something directly. If you've ever been in a situation where you knew you were being treated unfairly but felt powerless to stop it, you understand something of what Judge Thornton experienced in those 12 minutes. That helplessness, that rage that has nowhere to go. That knowledge that speaking up might only make things worse. If this resonates with you, drop a comment below and share your experience. And if you're finding this story compelling, make sure you subscribe so you don't miss how it ultimately unfolds. The backup unit arrived with lights flashing but no siren. Deputy Maria Santos had been patrolling a parallel stretch of highway when the call came through. At 29 years old, she had been with the Clayton County Sheriff's Office for just under 4 years. She was still young enough in her career to remember why she had become an officer in the first place, a genuine desire to serve her community, to help people, to be one of the good ones. As Santos pulled her vehicle behind Mercer's, she took in the scene with a practiced eye. A luxury sedan on the shoulder, a woman in professional clothing standing with her hands on the vehicle's roof, Mercer approaching her patrol car with a swagger that she had come to recognize over the years, a walk that said he was enjoying this more than the situation warranted. "What do we have?" Santos asked as she stepped out of her vehicle. Mercer's expression carried a hint of something between amusement and annoyance. "Got a suspicious one here. Claims to be an attorney, but the story's not adding up." She's been uncooperative. Santos glanced toward the woman by the Lexus. Even from this distance, she could see the rigid composure in the woman's posture, the kind of stillness that suggested someone holding themselves together through sheer force of will. She had seen that posture before, usually in people who were frightened but trying not to show it. Uncooperative how? Questioning everything, asking why she was stopped, asking why she needed to exit the vehicle. You know the type. Santos did know the type. She also knew that asking questions during a traffic stop was not, by any legal definition, uncooperative. It was the exercise of constitutional rights that every American possessed. But she had learned over her years working with Kevin Mercer that pointing out such distinctions was rarely productive. She walked toward the Lexus, her approach measured and deliberate. As she drew closer, she could see more details. The quality of the woman's clothing, the professional cut of her hair, the wedding ring catching light from the patrol cars. Nothing about this woman suggested anything other than exactly what she appeared to be, a professional woman on her way home from work. "Ma'am, I'm Deputy Santos. How are you doing tonight?" Judge Thornton turned her head slightly, just enough to see the female officer approaching. Something in Santos's tone, some quality of genuine concern rather than theatrical authority, prompted her to respond more fully than she had to Mercer. "I've been better, Deputy. I've been standing here for quite some time without any explanation of why I was stopped in the first place. I was driving precisely at the speed limit. I haven't violated any traffic laws. And I've cooperated completely with every instruction given to me." Santos nodded slowly, processing this information. She looked toward Mercer, who had followed her at a distance and was now standing with his arms crossed, watching the exchange with evident displeasure. "Kevin, what was the initial reason for the do not consent to any search of my person or my vehicle? I have provided my license and registration as required by law. I have complied with every instruction given to me. But I have constitutional rights, and I am asserting them now." The words landed like stones in still water, sending ripples through the encounter. Santos watched Mercer's expression shift, saw the calculation happening behind his eyes. For her part, Santos felt something twist in her stomach, a recognition that this situation was about to get worse rather than better. "You want to play it that way?" Mercer stepped forward, his posture aggressive. "Fine. If you're really an attorney, you should know that I can search your vehicle under the automobile exception if I have probable cause." "And what probable cause do you have, Deputy?" The question came from Judge Thornton with the quiet authority of someone who knew the answer before asking. It was the voice she used in her courtroom when an attorney was about to walk into a trap of their own making. Mercer heard it too, and it only increased his agitation. "I don't need to explain my probable cause to you." "Actually, Deputy, you do. If you search my vehicle without my consent and without articulable probable cause, any evidence you discover will be inadmissible. More importantly, you will have violated my Fourth Amendment rights." Santos took a step back, creating physical distance from what she sensed was about to happen. She had witnessed stops like this before, had seen Mercer escalate situations that should have remained routine. But there was something different about tonight. Something in the way this woman spoke that suggested she was not an ordinary motorist. "I'm going to ask you one more time," Judge Thornton continued, her voice remarkably steady. "What is your probable cause for this stop, and why have you detained me for over 20 minutes without charging me with any offense?" And then she said it. "My name is Denise Thornton. I am a judge on the United States District Court for the Middle District of Georgia, and I am asking you, formally and for the record, to either cite the legal basis for my continued detention or release me immediately." For a single heartbeat, everything stopped. The passing cars seemed to fade into silence. The flashing lights seemed to freeze in their rotation. Santos felt her breath catch in her throat. Even Mercer, for just a moment, looked genuinely stunned. But then his expression shifted, hardened, transformed into something that looked dangerously like defiance. "A federal judge," his voice dripped with skepticism. "Really? And I'm the president. Lady, I don't know what game you're playing, but impersonating a federal officer is a crime." "I'm not impersonating anyone. My judicial identification is in my vehicle, in my briefcase on the back seat. If you allow me to retrieve it, I can verify my identity." "You're not retrieving anything. You're going to stay exactly where you are." Santos stepped forward. "Kevin, maybe we should just let her get her ID." If she is who she says she is. She's not. Mercer cut her off with a sharp gesture. She's running a scam. This is exactly what I was talking about. Suspicious behavior, uncooperative attitude, and now this elaborate story. She probably stole that car. The accusation landed like a physical blow. Judge Thornton, who had maintained her composure through every moment of this encounter, felt something crack in her carefully constructed calm. Here it was. The unspoken assumption finally spoken aloud. A black woman could not possibly own a luxury vehicle, could not possibly be a federal judge, could not possibly be telling the truth about her own identity. I did not steal my vehicle, she said, and despite her best efforts, a tremor had entered her voice. I purchased it from Lexus of Macon 4 years ago. The registration you are holding is in my name. The title is in my name. I can provide you with any documentation you require. What I require is compliance. Turn around, hands behind your back. The world seemed to narrow to a single point of light, surrounded by darkness. Deputy Santos would later describe this moment as the one where she knew everything had gone wrong, where she saw a colleague cross a line that could never be uncrossed. She watched as Mercer produced his handcuffs, watched as Judge Thornton stared at the metal restraints with an expression that mixed disbelief with horror. You cannot be serious. The judge's voice had dropped to barely above a whisper. You are about to handcuff a federal judge. You are about to arrest someone who has committed no crime. Do you understand what you are doing? Mercer's response would become the centerpiece of the lawsuit that followed, would be replayed in courtrooms and on news broadcasts, would be cited in legal briefs and civil rights workshops for years to come. I don't care who you say you are. Right now, you're just another suspect, and you need to learn some respect for law enforcement. We'll figure out the charges later. The handcuffs clicked shut around Judge Thornton's wrists. There is something profoundly disorienting about being restrained against your will. Even when you know intellectually that you have done nothing wrong, the physical reality of bound hands creates an immediate sense of powerlessness, of vulnerability, of fundamental violation. For Judge Thornton, who had sent people to prison, who had ordered defendants released on bond, who had spent her career weighing questions of liberty and confinement, the sensation of those metal cuffs was almost unbearably surreal. She was placed in the back of Mercer's patrol car, positioned behind the cage that separated the front seats from the rear. Through the mesh, she could see the dashboard camera, could see its small red light indicating that it was recording. That camera, she knew, was capturing everything, every word that had been spoken, every action that had been taken, every violation of her constitutional rights. Meanwhile, Mercer had returned to her vehicle. Despite her explicit statement that she did not consent to a search, he opened the driver's door and began going through the interior. The dashboard camera in his vehicle recorded him opening her glove compartment, rifling through her center console, and eventually retrieving her briefcase from the back seat. What he found inside that briefcase should have ended the encounter immediately. There were legal briefs marked with the seal of the United States District Court. There were correspondence letters addressed to the Honorable Denise Thornton. There was her judicial identification card, complete with her photograph and official credentials. Deputy Santos, who had been standing at a distance watching this unfold, approached as Mercer emerged from the Lexus with the briefcase in hand. She saw him open it, saw him examine the contents, saw the moment when the reality of what he had done began to register on his face. "Kevin, what is all that?" Mercer didn't answer immediately. He stood there in the pulsing blue light, surrounded by evidence that he had just handcuffed and detained a sitting federal judge for no legitimate reason. Any reasonable officer faced with this discovery would have immediately released the detainee, apologized profusely, and begun damage control. Mercer did none of these things. "It's probably forged," he said finally. "We'll let the station sort it out." Santos stared at him with undisguised disbelief. "Kevin, that's a federal judicial ID. That's real court paperwork. You need to let her go." "I need to complete this stop properly. We're taking her in." "For what charges?" "I'll figure it out on the way." This is the moment where I need to ask you to really consider what you're hearing. An officer, confronted with irrefutable evidence that he had made a catastrophic error, chose to double down rather than admit fault. He chose to transport an innocent woman to jail rather than acknowledge that he had been wrong. He chose to compound his violation of her civil rights rather than attempt any form of correction. This is what we mean when we talk about abuse of power. This is what we mean when we talk about a system that protects its own at the expense of the people it's supposed to serve. And if you think this kind of thing only happens in stories, if you believe that surely there are safeguards against this kind of behavior, keep watching, because what happened next will test that belief to its limits. Judge Thornton was transported to the Clayton County Detention Facility, a journey of approximately 25 minutes during which she sat in silence, her mind cycling through disbelief, rage, and a cold determination that this encounter would not end here. She had been in these facilities before, but always as a visiting judge, never as an inmate. Now she saw them from the other side of the bars, experienced the dehumanizing processing procedures that she had only read about in countless case files. She was fingerprinted. She was photographed. She was asked to remove her jewelry and turn over her personal effects. Through all of it, she maintained her composure, speaking only to confirm her name and to repeatedly state that she was a federal judge who had been illegally detained. Each time she said this, the processing officers exchanged skeptical glances. Each time they continued with their procedures as if she hadn't spoken at all. The intake officer, a woman in her 40s with the practiced weariness of someone who had heard every possible claim from every possible detainee, barely looked up when Judge Thornton again asserted her identity. "Ma'am, everyone in here is innocent. Everyone in here has a story. We'll sort it all out in the morning. I am demanding that you contact the federal courthouse in Macon. I am demanding that you verify my identity before placing me in a cell. I am a sitting federal judge, and I am being held without any legitimate charge." The officer finally looked up, something flickering in her eyes that might have been doubt, might have been recognition that this detainee was somehow different from the others who passed through these doors. "I'll make a note of your request. In the meantime, you'll be placed in a holding cell until we can sort this out." And so Judge Denise Thornton, who had served her country's judicial system with distinction for over a decade, was locked in a concrete cell with fluorescent lights that buzzed and flickered, surrounded by the sounds of other detainees, denied access to her phone, her attorney, or anyone who might intervene on her behalf. She spent nearly 5 hours in that cell. The call that finally triggered her release came not from the jail itself, but from Judge Thornton's husband Gregory, who had grown increasingly concerned when his wife failed to arrive home at her expected time. His calls to her cell phone went straight to voicemail. His texts remained unread. By midnight, his concern had transformed into genuine alarm. Gregory Thornton was a retired prosecutor, a man who understood the legal system as intimately as his wife did. When his attempts to locate her through conventional means failed, he began working his contacts in law enforcement, first locally, then expanding outward. At approximately 3:15 a.m., he reached a sheriff's deputy who owed him a favor from their days working together in the district attorney's office. That deputy made some calls, accessed some databases, and delivered news that Gregory would later describe as the most terrifying phone call of his life. His wife had been arrested. She was currently being held at the Clayton County Detention Facility. There were no formal charges filed against her. Within the hour, Gregory Thornton was on the phone with the chief judge of the federal district, a woman named Patricia Collins, who had served alongside Denise for 8 years. Chief Judge Collins, awakened from her sleep by the call, listened to what Gregory told her with mounting fury. She immediately placed calls of her own, cutting through bureaucratic layers with the kind of authority that only a senior federal judge could muster. At 4:23 a.m., a command came down from the Clayton County Sheriff himself. Release Denise Thornton immediately, file no charges, and preserve all records and evidence related to her detention. The cell door opened with a metallic clang that echoed through the holding area. A visibly nervous facility administrator appeared at the threshold, accompanied by 2 officers whose expressions suggested they had just learned exactly who had been locked in their jail for the past 5 hours. Judge Thornton. The administrator's voice was strained, careful. "There's been a serious misunderstanding. We're going to release you immediately. Your husband is waiting in the lobby." Judge Thornton rose from the thin mattress where she had been sitting. Her professional attire was wrinkled now, her hair somewhat disheveled, but her eyes held the same steady intensity they had carried through her entire ordeal. "I want a copy of every piece of documentation related to my detention. I want the name and badge number of every officer who processed me. And I want confirmation that all recording devices in Deputy Mercer's vehicle were functioning and that the footage has been preserved. The administrator swallowed visibly. Yes, Your Honor. Of course. We'll provide whatever you need. She walked through those jail doors into the antiseptic light of the lobby, where Gregory waited with Chief Judge Collins and, surprisingly, two attorneys from the Federal Public Defender's Office who had been roused from their beds to assist. The reunion with her husband was brief, but intense, a moment of profound relief that neither of them would ever fully be able to describe. But even as Gregory held her, even as he whispered reassurances and questions about her welfare, Judge Thornton's mind was already moving forward. She was thinking about the dashboard camera footage. She was thinking about Deputy Mercer's personnel file. She was thinking about all the other people who had encountered him on that highway, people who didn't have the resources or the connections to fight back. She was thinking about justice and how she was going to pursue it. The lawsuit was filed 17 days later. Judge Thornton retained the law firm of Morrison & Associates, a prominent civil rights practice based in Atlanta. The lead attorney on the case was a woman named Vanessa Morrison, who had built her reputation on police misconduct cases and had never lost a civil rights lawsuit that went to trial. When Judge Thornton walked into her office and recounted what had happened on Interstate 75, Morrison listened with the focused intensity of someone who recognized both the magnitude of the case and its broader implications. Your Honor, what you've described is a textbook violation of the 4th and 14th Amendments, but I have to be direct with you. This case is going to attract enormous attention. It's going to be scrutinized by every media outlet in the country, and the defense is going to try everything they can to discredit you, to suggest that you provoked this encounter somehow, to make this about anything other than what Deputy Mercer did. Judge Thornton nodded slowly. I understand. And I want to be equally direct with you, Ms. Morrison. This case is not primarily about me. It's about every person Deputy Mercer stopped before me, every person who couldn't fight back, every person who assumed they had no recourse against this kind of treatment. I want this case to expose the pattern, not just the incident. Morrison smiled slightly. That's exactly what I was hoping you'd say. The discovery process that followed was revelatory in the most damning possible sense. When subpoenas compelled the Clayton County Sheriff's Office to produce Deputy Mercer's personnel records, what emerged was a decade-long pattern of complaints and concerns and systematic failures to address them. The file was thick with documentation, not of an officer gradually improving and learning from mistakes, but of someone who had been repeatedly accused of the same behaviors and repeatedly allowed to continue unchecked. There were 19 formal complaints in Mercer's file over his 9 years with the department. 16 of those complaints had been filed by black motorists. The allegations were remarkably consistent. Pretextual stops based on vague claims of suspicious behavior, aggressive questioning about vehicle ownership, invasive searches conducted without consent, and an overall demeanor that multiple complainants described as threatening and racially hostile. One complaint stood out for its eerie similarity to Judge Thornton's experience. 3 years earlier, a thoracic surgeon named Dr. William Patterson had been stopped by Mercer on the same stretch of Interstate 75. Dr. Patterson, driving a BMW sedan, had been questioned for over an hour about how he could afford such a vehicle. He had been subjected to a pat-down search and had his car thoroughly examined. The encounter ended only when Dr. Patterson's hospital called his cell phone to inform him that his patient was being prepped for emergency surgery and asking when he would arrive. The complaint doctor Patterson filed afterward had been investigated for exactly 11 days before being marked unfounded due to insufficient evidence. The dashboard camera footage from Mercer's vehicle that night had been lost due to a data storage malfunction. Then there was the case of attorney Patricia Simmons. Stopped 18 months before Judge Thornton, Simmons had been traveling to a courthouse in an adjacent county when Mercer pulled her over, allegedly for a broken taillight. Her taillight, as photographs would later prove, was not broken. She had been questioned about her vehicle, her occupation, and her destination. When she identified herself as a practicing attorney, Mercer had laughed and asked if she was sure she wasn't mistaking herself for a secretary. That complaint had also been marked unfounded. The dashboard footage was reported as having been accidentally recorded over. The pattern extended further. A construction company owner named Raymond Jefferson had been stopped 8 months before Judge Thornton and detained for nearly 3 hours based on Mercer's claim that the vehicle might be stolen. The vehicle was not stolen and had never been reported as such. A college student named Darius Williams had been stopped during finals week, detained for 70 minutes, and had missed a critical study session that contributed to his failing a course. A physician named Dr. Clarissa Roberts had been stopped while responding to a medical emergency and delayed for 35 minutes, leading to questions about whether the delay had affected patient outcomes. In every case, the complainant was black. In every case, the complaint was dismissed with minimal investigation. In every case, any available footage had somehow been lost, damaged, or overwritten. Morrison's team also obtained statistical data that painted an even more damning picture. Over his 9-year career, Mercer's traffic stops showed dramatic racial disparities when compared to his colleagues. He stopped black motorists at more than 7 times the rate of other deputies patrolling similar areas. His search rate for black drivers was 14 times higher than his search rate for white drivers. And perhaps most tellingly, despite these dramatically higher rates of stops and searches, his contraband discovery rate for black motorists was actually lower than department averages. In other words, Mercer was stopping and searching black drivers far more often than his colleagues, but finding evidence of actual criminal activity far less often. This was not effective policing. This was not data-driven enforcement. This was racial profiling, documented and quantifiable, hiding in plain sight in department statistics that no one had apparently bothered to analyze. Let me take a moment to address something directly. I know some of you watching might be thinking that this is an exceptional case, that Deputy Mercer was simply a bad apple, that this doesn't represent law enforcement as a whole, and I want to acknowledge that perspective while also pushing back against it. The problem was never just Kevin finding value in this breakdown. Take a moment to subscribe and share this video. Stories like this only drive change when enough people hear them. The trial began on a crisp Monday morning in November in a courtroom that was packed beyond capacity. The case had attracted national attention. Civil rights organizations had filed amicus briefs supporting Judge Thornton. Police unions had issued statements defending Mercer's right to make judgment calls in the field. Legal commentators had written extensively about the implications of the case for both civil rights jurisprudence and law enforcement practices. When Judge Thornton entered the courtroom, not as a jurist but as a plaintiff, the tension in the room was palpable. The presiding judge, Honorable Samuel Fletcher, was a colleague of Thornton's who had agreed to take the case only after extensive discussion about potential conflicts of interest. His opening instructions to the jury were careful and precise, emphasizing that they must evaluate the evidence without regard to Judge Thornton's position or status. "You must consider the facts of this case as you would for any plaintiff," Judge Fletcher instructed. "The question before you is whether this plaintiff, regardless of her occupation, was subjected to unlawful treatment by the defendants. Her position as a federal judge may inform your understanding of certain aspects of her testimony, but it should not bias your assessment of the fundamental questions of law and fact." Morrison's opening statement laid out the case with devastating clarity. She described the stop itself in granular detail, walking the jury through each moment from the initial activation of Mercer's lights to Judge Thornton's eventual release from custody. She introduced the dashboard camera footage that had been preserved, in this case, only because Judge Thornton had explicitly demanded its retention within hours of her arrest. Then she broadened the scope, introducing the pattern evidence that would form the heart of her argument. This was not, she explained, an isolated incident of poor judgment. This was the culmination of years of discriminatory behavior that the Clayton County Sheriff's Office had known about, documented in their own files, and systematically failed to address. "You will hear testimony from other victims of Deputy Mercer's behavior," Morrison told the jury. "You will see the statistics that prove his stops were not based on traffic violations, but on the color of driver's skin. And you will see documentation that proves his superiors knew about these patterns and chose to do nothing. This is not about one bad stop. This is about a department that created the conditions for this stop to happen and then protected the officer who made it." The defense's strategy was immediately apparent: minimize, deflect, and cast doubt. Mercer's attorney, a veteran of police union cases, argued that the deputy had acted in good faith based on his training and experience. Yes, the stop had been initiated based on subjective observations rather than clear violations, but officers, he argued, must be allowed to exercise judgment in the field. The alternative would paralyze law enforcement and make communities less safe. As for the handcuffing and transport to jail, the defense contended that Mercer had genuine doubts about Judge Thornton's identity. In an era of sophisticated document forgery and elaborate criminal schemes, was it so unreasonable for an officer to verify extraordinary claims through proper channels? It was, Morris encountered in her rebuttal, absolutely unreasonable, because Mercer hadn't attempted to verify anything. He had made no calls to verify judicial credentials. He had filed no charges that would require such verification. He had simply decided that a black woman could not possibly be what she claimed to be, and had acted on that assumption with the full force of his authority. The testimony phase of the trial stretched over 2 weeks. Dr. William Patterson took the stand and described his encounter with Mercer in terms that mirrored Judge Thornton's experience almost exactly. The aggressive questioning about vehicle ownership, the invasive search, the unspoken but unmistakable implication that a black man driving a luxury car must have acquired it through illegitimate means. "I saved 3 lives that week in the operating room," Dr. Patterson testified, his voice tight with controlled emotion. "I have a medical degree, a surgical fellowship, and 2 decades of experience, but to Deputy Mercer, I was just a suspect." That's what he saw when he looked at me. Not a healer, not a professional, just a suspect. Patricia Simmons described how her encounter with Mercer had affected her professionally and personally. She had filed her complaint with high hopes that it would lead to accountability. When it was dismissed, she had felt a crushing sense of futility that had taken months to overcome. "I was actually relieved when I heard about Judge Thornton's case," Simmons admitted. "Not because of what happened to her. That was horrible. But because finally, someone who couldn't be ignored had experienced what we'd all experienced. Finally, there would be a reckoning." Dr. Clarissa Roberts testified about the emergency she had been responding to the night Mercer stopped her. The patient, a car accident victim with internal bleeding, had survived, but Roberts had often wondered what might have happened if the delay had been longer, if the injuries had been slightly more severe. "I took an oath to do no harm," she said, "but that night, someone with a badge and a gun prevented me from honoring that oath, and when I complained about it, nothing happened. Absolutely nothing." Perhaps the most powerful testimony came from an unexpected source, Deputy Maria Santos. Santos had been placed on administrative leave pending the investigation and trial. She had received pressure from multiple directions to support Mercer's version of events, to characterize Judge Thornton as combative and uncooperative, to help construct a narrative that would justify what had happened. Lieutenant Thomas Graham, Mercer's direct supervisor, had called her into his office 3 times to discuss the importance of presenting a unified departmental position. Anonymous notes had appeared in her locker warning her about the consequences of betraying fellow officers. Her union representative had subtly suggested that her career prospects might be limited if she testified in ways that were unhelpful to the defense. Despite all of this, Santos chose to tell the truth. "I witnessed Deputy Mercer stop a woman who had committed no traffic violation," she testified, her voice steady despite the obvious tension in her posture. "I witnessed him order her out of her vehicle without justification. I witnessed him conduct a search without consent and without probable cause. I witnessed him handcuff her and place her in his vehicle despite having no legal basis to do so." The defense attorney attempted to rattle her on cross-examination, suggesting that she was motivated by personal animosity toward Mercer, by a desire to advance her own career at his expense, by pressure from civil rights groups who had contacted her after the incident. Santos responded to each suggestion with the same measured denial. "I'm testifying because I took an oath to serve and protect. Part of that oath means telling the truth, even when it's hard. Deputy Mercer violated that woman's rights. I saw it happen, and I will not lie to protect him." In the gallery, several jurors were visibly moved. One woman wiped her eyes. Another nodded almost imperceptibly as Santos spoke. The statistical evidence was presented through expert witnesses who had analyzed Mercer's traffic stop data over his 9-year career. Doctor: Christine Park, a criminal justice professor from Emory University who specialized in policing patterns, walked the jury through the numbers with methodical precision. The disparities we see in Deputy Mercer's data are not statistical noise, Dr. Park explained. They represent a consistent pattern that cannot be explained by geography, time of day, or any other neutral factor. The only variable that explains these numbers is race. Deputy Mercer stopped black motorists at rates that were dramatically, significantly, and consistently higher than any legitimate enforcement justification would produce. She displayed charts showing Mercer's stop rates compared to his colleagues, his search rates compared to department averages, and his contraband discovery rates that demonstrated the ineffectiveness of his approach as actual crime prevention. If Deputy Mercer's stops were based on legitimate traffic safety concerns or accurate identification of suspicious behavior, we would expect his contraband discovery rates to be at least comparable to his colleagues. Instead, they were lower. He was stopping more people and finding less actual wrongdoing. What does that tell us? It tells us that his criteria for identifying suspicious behavior were not actually predicting criminal activity. They were predicting something else entirely. The defense's expert witness, a former police trainer who now worked as a consultant, attempted to explain away the disparities as a function of patrol assignment and other variables. Under Morrison's cross-examination, however, his arguments crumbled. He was forced to admit that he had not analyzed Mercer's data himself, that he was relying on defense-provided summaries, and that his general theories about patrol assignment patterns didn't actually apply to Mercer's specific circumstances. The institutional evidence was equally damning. Morrison introduced internal emails from the Clayton County Sheriff's Office that revealed awareness of complaints against Mercer dating back years. Lieutenant Graham had received summaries of these complaints and had consistently recommended no disciplinary action. In one email, he had praised Mercer's proactive approach to identifying suspicious individuals, a phrase that Morrison highlighted with pointed emphasis. Training records showed that Mercer had not received any updated instruction on bias recognition, constitutional limitations on stops and searches, or de-escalation techniques in over 6 years. The department's policies on dashboard camera footage retention were revealed to be so loose that evidence was routinely lost or overwritten, creating a convenient gap in documentation whenever complaints arose. This is not just about one officer, Morrison argued in her closing statement. This is about a system that allowed this officer to victimize member after member of the black community while doing nothing to stop him. This is about supervisors who saw the complaints and chose to look away. This is about policies designed to destroy evidence and protect wrongdoers. This is about a culture of impunity that told Kevin Mercer year after year that he could do whatever he wanted to black motorists without consequence. She paused, looking at each member of the jury in turn. And today, you have the power to end that impunity. You have the power to say that this is not acceptable, that the Constitution applies on dark highways just as much as it does in courtrooms, that wearing a badge does not grant anyone the right to violate another person's fundamental dignity and freedom. The defense closing attempted to reframe the narrative one final time, portraying Mercer as a dedicated officer who had made an unfortunate error in an ambiguous situation. The attorney emphasized the difficulties of traffic enforcement, the split-second decisions officers must make, the dangers they face from people who lie about their identities. But the argument felt hollow against the weight of evidence that had been presented. The pattern was too clear, the documentation too damning, the testimony too consistent. The jury deliberated for just under 5 hours. When they returned to the courtroom, the foreperson rose with a verdict form in hand. The gallery fell silent. Morrison reached over and placed her hand briefly on Judge Thornton's arm. Mercer sat rigid at the defense table, his attorney whispering something in his ear that he appeared not to hear. On the question of whether Deputy Kevin Mercer violated the plaintiff's Fourth Amendment rights by conducting an unlawful stop, how does the jury find? We find for the plaintiff. On the question of whether Deputy Kevin Mercer violated the plaintiff's Fourth Amendment rights by conducting an unlawful stop, how does the jury find? We find for the plaintiff. On the question of whether Deputy Kevin Mercer violated the plaintiff's Fourth Amendment rights by conducting an unlawful stop, how does the jury find? We find for the plaintiff. On the question of whether Deputy Kevin Mercer violated the plaintiff's Fourth Amendment rights by conducting an unlawful stop, how does the jury find? We find for the plaintiff. On the question of whether Deputy Kevin Mercer violated the plaintiff's Fourth Amendment rights by conducting an unlawful stop, how does the jury find? We find for the plaintiff. On the question of whether Deputy Kevin Mercer violated the plaintiff's Fourth Amendment rights by conducting an unlawful stop, how does the jury find? We find for the plaintiff. On the question of whether Deputy Kevin Mercer violated the plaintiff's Fourth Amendment rights by conducting an unlawful stop, how does the jury find? We find for the plaintiff. On the question of whether Deputy Kevin Mercer violated the plaintiff's Fourth Amendment rights by conducting an unlawful stop, how does the jury find? We find for the plaintiff. On the question of whether Deputy Kevin Mercer violated the plaintiff's Fourth Amendment rights by conducting an unlawful stop, how does the jury find? We find for the plaintiff. On the question of whether Deputy Kevin Mercer violated the plaintiff's Fourth Amendment rights by conducting an unlawful stop, how does the jury find? We find for the plaintiff. On the question of whether Deputy Kevin Mercer violated the plaintiff's Fourth Amendment rights by conducting an unlawful stop, how does the jury find? We find for the plaintiff. On the question of whether Deputy Kevin Mercer violated the plaintiff's Fourth Amendment rights by conducting an unlawful stop, how does the jury find? We find for the plaintiff. On the question of whether Deputy Kevin Mercer violated the plaintiff's Fourth Amendment rights by conducting an unlawful stop, how does the jury find? We find for the plaintiff. On the question of whether Deputy Kevin Mercer violated the plaintiff's Fourth Amendment rights by conducting an unlawful stop, how does the jury find? We find for the plaintiff. On the question of whether Deputy Kevin Mercer violated the plaintiff's Fourth Amendment rights by conducting an unlawful stop, how does the jury find? We find for the plaintiff. On the question of whether Deputy Kevin Mercer violated the plaintiff's Fourth Amendment rights by conducting an unlawful stop, how does the jury find? We find for the plaintiff. On the question of whether Deputy Kevin Mercer violated the plaintiff's Fourth Amendment rights by conducting an unlawful stop, how does the jury find? We find for the plaintiff. On the question of whether Deputy Kevin Mercer violated the plaintiff's Fourth Amendment rights by conducting an unlawful stop, how does the jury find? We find for the plaintiff. On the question of whether Deputy Kevin Mercer violated the plaintiff's Fourth Amendment rights by conducting an unlawful stop, how does the jury find? We find for the plaintiff. On the question of whether Deputy Kevin Mercer violated the plaintiff's Fourth Amendment rights by conducting an unlawful stop, how does the jury find? We find for the plaintiff. On the question of whether Deputy Kevin Mercer violated the plaintiff's Fourth Amendment rights by conducting an unlawful stop, how does the jury find? We find for the plaintiff. On the question of whether Deputy Kevin Mercer violated the plaintiff's Fourth Amendment rights by conducting an unlawful stop, how does the jury find? We find for the plaintiff. On the question of whether Deputy Kevin Mercer violated the plaintiff's Fourth Amendment rights by conducting an unlawful stop, how does the jury find? We find for the plaintiff. On the question of whether Deputy Kevin Mercer violated the plaintiff's Fourth Amendment rights by conducting an unlawful stop, how does the jury find? We find for the plaintiff. On the question of whether Deputy Kevin Mercer violated the plaintiff's Fourth Amendment rights by conducting an unlawful stop, how does the jury find? We find for the plaintiff. On the question of whether Deputy Kevin Mercer violated the plaintiff's Fourth Amendment rights by conducting an unlawful stop, how does the jury find? We find for the plaintiff. On the question of whether Deputy Kevin Mercer violated the plaintiff's Fourth Amendment rights by conducting an unlawful stop, how does the jury find? We find for the plaintiff. On the question of whether Deputy Kevin Mercer violated the plaintiff's Fourth Amendment rights by conducting an unlawful stop, how does the jury find? We find for the plaintiff. On the question of whether Deputy Kevin Mercer violated the plaintiff's Fourth Amendment rights by conducting an unlawful stop, how does the jury find? We find for the plaintiff. On the question of whether Deputy Kevin Mercer violated the plaintiff's Fourth Amendment rights by conducting an unlawful stop, how does the jury find? We find for the plaintiff. On the question of whether Deputy Kevin Mercer violated the plaintiff's Fourth Amendment rights by conducting an unlawful stop, how does the jury find? We find for the plaintiff. Search. How does the jury find? We find for the plaintiff. On the question of whether Deputy Kevin Mercer violated the plaintiff's 14th Amendment rights by engaging in racially discriminatory enforcement practices, how does the jury find? We find for the plaintiff. The verdict continued through each count, each question answered with the same two words. for the plaintiff. On the question of damages, the jury awarded $680,000, a figure that reflected both compensation for Judge Thornton's ordeal and a punitive component meant to send a message about the consequences of civil rights violations. But the monetary judgment, while significant, was almost secondary to what happened next. The Clayton County Sheriff's Office was forced to implement sweeping reforms as part of the settlement agreement that accompanied the verdict. These reforms included mandatory bias training for all officers, stricter documentation requirements for traffic stops, enhanced oversight of complaint investigations, and the preservation of all dashboard and body camera footage for a minimum of 5 years. Deputy Kevin Mercer was terminated immediately. His pension, which he had been vesting over his 9-year career, was forfeited. His law enforcement certification was revoked, meaning he could never work as a police officer in Georgia again. Lieutenant Thomas Graham, who had supervised Mercer and signed off on the dismissal of multiple complaints, was demoted and transferred to a desk assignment pending further review of his conduct. Deputy Maria Santos, despite the pressure she had faced and the professional risks she had taken, was commended publicly by the sheriff in his statement following the verdict. Her courage in testifying truthfully, the sheriff said, represented the values that law enforcement should embody. Privately, Santos would later tell interviewers that the praise felt hollow. The same department that was now celebrating her had allowed the conditions that made her testimony necessary. The same supervisors who were calling her courageous had ignored the complaints that might have prevented Judge Thornton's ordeal in the first place. "I didn't do anything exceptional," Santos said in one interview. "I told the truth. That should be the baseline, not the exception." The fact that telling the truth was seen as courageous says something deeply troubling about the culture I was working in. Judge Denise Thornton held a press conference on the steps of the federal courthouse 2 days after the verdict. Flanked by her husband Gregory and her legal team, she spoke with the same measured precision that had characterized her entire approach to this case. "I want to be clear about something," she began. "This verdict is not primarily about me. What happened to me that night on Interstate 75 has happened to countless other people who did not have the resources, the connections, or the platform to fight back. This verdict is for them. This verdict is for every person who was stopped without cause, searched without consent, and dismissed when they complained." She announced that she would be donating the entirety of her settlement to establish a legal defense fund for victims of civil rights violations who could not afford representation. The fund, she said, would ensure that the next person targeted by officers like Kevin Mercer would have access to the same quality of legal advocacy she had received. "Justice should not depend on who you know or what you can afford," Judge Thornton said. "It should be the birthright of every American. This fund is my small contribution to making that principle a reality." The case resonated far beyond Clayton County. Media coverage spread the story across the country. Legal commentators analyzed its implications for civil rights law. Police departments in other jurisdictions quietly reviewed their own data, their own complaint files, their own footage retention policies, wondering if similar patterns existed in their own ranks. Civil rights organizations pointed to the case as proof that systemic change was possible when victims were empowered to fight back. Law enforcement advocates acknowledged that officers like Mercer damaged public trust and undermined the legitimacy of policing generally. And in communities across the country, people who had experienced similar treatment read about Judge Thornton's case and felt something shift in their understanding of what was possible. If a federal judge could be targeted this way, then perhaps their own experiences were not isolated incidents, not personal failures to comply properly, not exaggerations or misunderstandings. Perhaps they too had been victims of something larger, something systemic, something that was finally being named and confronted. So where does this story leave us? On one level, it leaves us with a victory. Judge Thornton prevailed. Mercer was held accountable. The department was forced to change. These are tangible outcomes that matter, that represent real progress, that demonstrate that the system can, sometimes, be made to work. But on another level, it leaves us with questions that are harder to answer. How many Kevin Mercers are out there in departments across the country whose patterns have not yet been documented, whose complaints have not yet accumulated, whose victims have not yet found the resources to fight back? How many Maria Santos are staying silent, afraid of the consequences of telling the truth about what they've witnessed? How many Judge Thorntons are driving on highways right now, pulled over for no legitimate reason, subjected to treatment that violates their constitutional rights, lacking the credentials and connections that eventually led to this particular outcome. These questions don't have easy answers, but asking them is itself a form of progress. Acknowledging that the problem exists, that it is systemic rather than isolated, that it requires ongoing vigilance rather than one-time fixes, this acknowledgement is the foundation on which meaningful change can be built. I want to close by asking you something directly. What would you do if you were pulled over without cause, questioned about your right to drive your own car, handcuffed despite having committed no crime? Would you have the presence of mind that Judge Thornton had? Would you have the resources to fight back? And if you didn't, would you want someone else to fight on your behalf? If this story moved you, if it made you think about these issues in new ways, if it made you angry or hopeful or both, then it's had its intended effect. Share it with someone who needs to hear it. Subscribe to this channel so you don't miss more stories like this one. And most importantly, carry these questions with you the next time you hear about a police encounter, the next time you vote on local sheriffs and prosecutors, the next time you have the opportunity to make your voice heard on issues of justice and accountability. Because stories like this one don't just inform us, they call us to action. And the action we take collectively will determine whether the progress represented by this verdict becomes a turning point or just a momentary exception. Judge Denise Thornton returned to her courtroom after the case concluded. She continues to preside over cases in the Middle District of Georgia, bringing to her work the same dedication to equal justice that defined her career before that night on Interstate 75, and that was only strengthened by what she experienced. But she has said in interviews that the experience changed her, not her commitment to the law, not her belief in the system, but her understanding of how that system fails the people it's supposed to protect. I always believed in equal justice, she said, but now I've lived the gap between that ideal and reality. I've felt what it means to be treated as less than human by someone who holds power over you, and that experience will inform every judgment I make for the rest of my career. Maria Santos eventually transferred to a different department in a neighboring county. She has been open about the difficulty of the experience and about her hope that her testimony made a difference. I lost some friends over this, she said. But I gained something more important. I gained the ability to look at myself in the mirror and know I did the right thing. That matters more than any of the rest of it. Kevin Mercer has not spoken publicly since his termination. According to sources, he has attempted to find work in private security, but has been turned down due to the publicity surrounding the case. His lawsuit against the department for wrongful termination was dismissed with prejudice. The Clayton County Sheriff's Office has reported that complaints against officers for racial profiling dropped by 64% in the 2 years following the implementation of the mandated reforms. Traffic stop data now shows patterns that are in line with demographic expectations. Dashboard camera footage retention compliance is at 99%. These numbers represent real change. They represent lives that were not disrupted, rights that were not violated, confrontations that did not escalate. They represent the ripple effects of one woman's decision to fight back, of one deputy's decision to tell the truth, of one jury's decision to hold power accountable. And they represent a reminder that change is possible. Difficult, painful, costly, but possible. That night on Interstate 75 began as an ordinary drive home. It ended as something much more significant, not because of who Judge Thornton was, but because of what she did with that identity when it mattered most. She stood up, she fought back, and she won. Not just for herself, but for everyone who couldn't. That's the story, that's the lesson, and that's the call to all of us. Stand up, fight back, and never accept injustice as inevitable.